Good afternoon. Thanks for joining us. This is the Aspen City Council work session for March 18th, 2024.
Sorry.
On our agenda this evening, a couple of items. We have open meetings and open records / council emails conference with some outside counsel, if you will. And then we have boards and commissions expectations. And then if we have time, we will get to some city manager board reports regarding CAST and the Airport Advisory Board that Sarah has been able to sit in on those meetings and be our liaison on the Airport Advisory Board. But we'll start off with our first one, which is open meetings and open records, council emails. Jen, did you want to introduce this item?
Yes, please. Jen Newton, Senior Project Manager in the City Manager's Office. And with me is Sam Light, who's the General Counsel for CIRSA. And I'm going to share my screen, if that's okay.
Please do.
And I will hand it over to Mr. Light.
Thanks, Jen. Hello, Mayor, Council. Good to see you all again. Staff, thank you for having me up this afternoon. Beautiful afternoon. Always a pleasure to come up and see you in Aspen. By way of introduction, my name is Sam Light, and I'm Deputy Executive Director and General Counsel for CIRSA. And I know we have at least one fairly new member of Council and some familiar faces, so good to see you all again. By way of background, CIRSA is an acronym. It stands for the Colorado Intergovernmental Risk Sharing Agency, which is kind of a mouthful, right? So that's why we call it CIRSA. So we're your insurance provider for property and casualty coverage. We're not a commercial insurance company. We're a Colorado public entity self-insurance pool. And our only business, our only members, our only insureds are Colorado cities and towns and affiliated entities. So we insure about 90% of the municipalities in the state of Colorado. That's almost all the municipalities except the real big ones, the Denvers, the Colorado Springs. They're kind of not appropriate for a pooling type of structure for insurance. But we insure almost all of the small to mid-size and almost all of the mid-size to mid-large cities around the state of Colorado. I left you, I think there was included in the meeting packet a copy of my presentation. One of the things that we do for our members is we do elected officials training. We try to get out and visit our members about once every 18 months or 2 years or so and meet with our elected governing bodies and talk about risk management from your perspective. So that's why I'm here this evening, to stop by and talk about risk management from your perspective. So there's my slides are in the packet. I left a couple of handouts at your places. One of them, the CIRSA at a Glance document, gives you a brief overview about services we provide at CIRSA. And then there's another handout that I'm going to mention as we go through the material, and that's suggestions for elected and appointed officials around the use of email. So we are going to talk about transparency issues as well, and talk about open meetings, emails, and a couple of other topics as well. So I do want to say that I want to make my time here this afternoon as useful to you all as possible. So if you have questions, feel free to ask me any question that you've got that you think we at CIRSA as your insurer can help, give you some risk management perspectives on. But please do, I have a pretty good radar. I've been doing trainings a long time and have a good radar for what I call the live one. So if my sense is that your question is kind of the live burning issue of the day here in the city, you know how it goes. Sometimes I'll be at a training and so, Sam, I've got a question. What if another member of the town board does this? And everyone's eyes open wide, and I get the sense that's going to be a pretty exciting discussion. I'll still give you thoughts from CIRSA's risk management perspective, but if it's a question for which you need legal advice, in the here and now for a pending issue that you've got going on, that's for your city attorney, Jim, and his team, and same thing for things that are in the city manager's bailiwick. All right, if that question relates to what Sarah needs to provide you advice and support on, then I may offer some thoughts from CIRSA's risk management perspective, but you do want to rely on your staff for support there. So thank you all for the opportunity to present. Thank you for being a member of CIRSA, we value and greatly appreciate our longstanding relationship with our CIRSA members. To give you a sense of that, the city joined CIRSA in 1982 for property and casualty coverage. That was the first year of CIRSA. So thank you for that longstanding membership. We value that relationship. We always like to hear from our members. If you have any concerns, you have a close point of contact maybe for sorts of things. Our board of directors is made up of member representatives, including on our board of directors, your city manager. But we always want to be responsive to our members' needs. So if there's anything that's on your mind about how we at CIRSA might improve on behalf of our members and provide services to our members, feel free to let us know. All right, to get going on my presentation, for those of you that I've presented to before, this may be a kind of a refresher, but I think it's good to check in on these concepts every so often. And for the newer folks, I hope the orientation training is helpful to you. I'm going to talk a little bit about this refresher on the role of being an elected official. Then we'll dig into some transparency issues. We'll talk about organizational structure and liability, and then I'll have a couple of concluding thoughts, including I just want to make a couple of high-level comments about the law enforcement liability world, because we read so much about that and see a lot going on there. So a reminder of this, but particularly for the newer folks, right? We recognize in the terms of risk management, my first slide here, my first suggestion regarding risk management from the governing body level may not sound like a risk management suggestion, but it really is, and that is to always remember that significant change that occurs in your role and relationship to the community when you become an elected official, because you're no longer just a citizen of the city, right? You're now a government official, and I'm kind of here to tell you that's a 24/7 job from a certain perspective, right? In the eyes of your constituents, in the eyes of the citizens, in the eyes of people that you take your counsel from, they will always perceive you to be a representative of the city, to be a member of the city council, and a representative of this organization. It doesn't matter where or when you have that interaction, right? Do you all interact with citizens? Sure you do, right? Sometimes a citizen may ask you, council member, what do you think of this issue? And maybe your own radar is going off, and what's council going to do about this? And you're thinking, well, wait a second, we at council, we haven't really set aside time to talk about that yet. But maybe that person's insistent. They say, oh, that's okay, but what's your opinion? And you may even, temper your comments by saying, well, this is my personal opinion. This is my personal opinion. What are your citizens filtering in that interaction? Council member, council member, council member, right? And as they should, your words, your deeds, your conduct matters, leaves an impression, has an effect when you as a council pass laws and policies that affect people's lives, has a huge significance, right? And your citizens will always perceive you to be in that role. It may sound a little bit fair at times because we're entitled to a personal life, but in the eyes of your constituents, they will always perceive you to be a representative of the council as an institution. Also recognize you're no longer an outsider to city government. You're now the ultimate insiders, right? That has meaning from a risk management standpoint. For the new member, Councilmember Rose, I hope that the first thing you didn't receive when you became a council member was that big ordinance book. I don't think they publish them that way anymore anyway. It's all online. But there are still hundreds of pages, right, of ordinances and policies that dictate how the council handles decision-making both substantively and procedurally. And now that we're on the inside and we're a member of the governing body, we're duty-bound by law to follow those rules. We can't take an outsider perspective. Sometimes the temptation is, well, that's not a good rule. But as long as it's in place, we're duty-bound to apply those rules as written. As the legislative body, maybe you can change them, but you need to do that in consultation with your staff within the appropriate legal framework. Recognize also that in the role of elected governing body member, right, that role is this high-level role of being an ambassador for the organization, right, a representative of the council as an institution, a steward of the best interest and assets of the city as a corporation, and a fiduciary, right? The fiduciary I say for last, but that's the one that's most familiar to attorneys, right? The concept, the fiduciary responsibility is that legal concept of the obligation under law to put the interests of the organization that we serve as fiduciary above all other interests, above personal interests, right? That ain't easy sometimes, right? Sometimes you may have a small but vocal minority comes to the council meeting and says, council, do this. The next person who stands up during public comment says, council, don't do that. Do exactly the opposite, right? From where you sit as the council in figuring out, what is our fiduciary duty, what's most protective of the city in terms of its interest and assets, I think one of your strengths, one of your prerogatives, kind of one of your rights as a council is to take the time that you need and get the information that you need that will help you, right, serve that purpose of ensuring that you're the stewards of the city's best interests. You know how it happens. Sometimes maybe somebody brings something up during public comment, and to you, you're thinking, well, this is new to me, right? If that's your sense on council, right, then, frankly, be selfish about taking the time you need. Maybe you need input from Sarah and her team on, do we have resources for this? Where does this fit in our work plan? Maybe you have questions for Jim. Do we have authority to get involved in this issue? Those kinds of things. So it serves you well. Once in a while in our area, in handling risk and claims for you, once in a while there are claims born of a dispute over something where we get down the road a little bit and we realize that maybe that decision was a little premature, or it wasn't ripe, or it was a decision made in haste. So as council, you do want to be protective of that power you have to take the time you need and get the information you need to serve the best interest of the city. Okay, we're going to talk a little bit later about the job description being on elected governing body. But one of the jobs, of course, for the elected governing body, it's true for everybody in the organization, but particularly for elected and appointed officials, because you do so much of your work in a public-facing manner, is one of the jobs is delivering good governance, right? Which I think at root depends upon, from a risk management perspective as well, in terms of committing to a couple of core civics principles. And I've broken a couple down on the slide. I'm only going to mention a couple of them, but before I do that, I have to ask this question too. This is true for the veterans and the newer folks. Do you like process? Do you like process, right? You have to, right? In local government, one of the products that we provide is process in and of itself, right? Embrace process as a product that you deliver in and of itself. Embrace process irrespective of outcome, irrespective of whether you're on the majority of an issue or a minority of an issue. In that process, always commit to consider the merits of issues on their own, right? And that'll serve you well. But if you think about it, at the end of the day, process is a product that you as the council deliver. You provide a forum and a venue, this location, for people to come and talk about the needs and wants of the city, and you can help decide at that governing body level how we put governmental resources on that. But that's a process, and you want folks to walk away from your process, irrespective of whether they may disagree with your decision. They walk away thinking that was a good process. I feel like I was heard. I feel like I was respected. I think council had a good deliberation on the issue. What a wonderful place to be in terms of building faith and trust in the council. And correspondingly, I think risk does go down, and if that's the sense, right, of your view of embracing process. So a couple of these good governance concepts, the civics principles on the left-hand side of the slide, the corresponding legal issue is on the right-hand side. If you embrace openness and transparency, you'll have few, if any, claims, disputes, lawsuits over compliance with the open meetings law, the open records law. Doesn't mean you won't get open records requests. I just heard you got quite a few already, right? But in terms of litigation risk, if we as council embrace those kind of concepts and understand the obligations around transparency, we're going to help manage risk. Commit to fundamental fairness. For you all, that issue probably, if it comes up at all at the governing body level, maybe in the public hearing context, when you're making land use decisions or things like that. In terms of managing that risk, staff takes care of almost all of that for you. They make sure the packet is proper, that hearing notice is proper, that kind of thing. But if it comes up at all, from where you sit as the governing body, if anyone ever stands up during public comment and says, I object to this process, what you want to do is just slow it down. It's usually the mayor, presiding officer will look to staff, do we have an issue here? And what we ask that you do is, and I'm sure you do this quite well, is just make a record of how that procedural objection was being handled. Commit to being predictable and even-handed, right? Builds faith and trust in your decision-making process. You don't want to be in a situation where the accusation is someone has a request in front of council, maybe it's a type of request that comes up on a recurring basis, and you have an applicant or someone who's making the request, and their view of it is that on the night the council considered my request, that's the first time. The council, lo and behold, took a novel and unprecedented interpretation of their own rules and turned me down. They may feel like they were treated differently than a similarly situated applicant. That's an equal protection type of claim. Or they may believe that the reasons for your decisions were arbitrary. And there's a different legal vehicle that I mentioned in the slide here for that purpose. Commit always to civility and mutual respect. Right? Sometimes the job requires even civility in the face of incivility. But you're up to that, right? You can't control every dynamic of your interactions with the public or what's going on social media, but you can control 90 to 95% of how your meetings go, right? Tone and temperament and style. Mutual respect for each other as council members, for citizens that come in front of you, for staff. Your meetings should always be a safe space for no matter how different our opinions on an issue, that each council member feels like they can express their view no matter how different than anyone else's, and feel like the other members are actively listening, that we can have disagreements without being disagreeable. And that'll go a long way to avoiding problems in that area. Sometimes people ask, well, why is that a CIRSA issue, right? But we do, knock on wood, not that often, but once in a while, we do have claim situations that are born out of inter-strife, right? Where when I get that call, it's usually we're way down the road, right? And someone, elected or appointed official, is calling me and saying, we're having some internal turmoil and we have this one member who's not doing things the way we want. How do we remove him from office? And there's the legal question, right? That kind of thing. But I think good risk management around avoiding those situations starts earlier, right? Of asking, wise bodies have the strength to say, what's really bothering us? Even if we end up agreeing to disagree, do we have the strength, right, internally to talk about what does it take to make sure we have an agreed upon norm of conduct of mutual respect, active listening, appreciating each other's perspectives. That's all just part and parcel of being a member on a multi-member governing body. Okay? Let's, unless there are questions, thoughts on that issue, let's pivot to transparency. I'm sure that your staff and the legal department covered this issue a number of times, but I just want to start, particularly for the new folks, with the basic building blocks of the open meetings law. And there's a lot going on in that statute, but we all remember, right, that the open meetings law, and here I'm just talking about as applied to the city council as a 5-member local public body. That law says that whenever 3 or more members of the council meet to discuss public business, that's a meeting that has to be open to the public. And that simply means the citizens have a right to observe that discussion. The second major part of the statute says that if the council is going to take any kind of action, adopt a position, pass an ordinance, pass a resolution, take any other kind of formal action, that can only occur in a duly called and noticed public meeting at which an agenda is posted in advance and your staff takes care of that. So that's all easy peasy. Yes, Mayor.
Is this 3 in relationship to being a 5-member board, or is it the rule of 3? Does that carry forth on councils that are 7-member boards?
The rule of 3 applies even for a 7-member board. Yeah, there's a little bit of a nuance in there that says it's 3 or a quorum, whichever is less. So think of 3-member boards of county commissioners. It would kick in for them for 2. Maybe internally think of your own, do we have any formally constituted committees that have 3 members, right? That kind of thing, okay? So that's all easy peasy. There are a couple things, sometimes people ask me, okay, well, if 3 or more council members meet, That's an open meeting. That means the citizens have a right to be there, observe the discussion. Does that apply when 4 or 5 members of the council go out for a social occasion? Or three or four members of the council just bump into each other at the coffee shop? I don't know if you're still having coffee, but if I had time, I would have gone there before the meeting, right? Is that a violation? You know, you can hear it now. The governmental watchdog looks over and sees 4 of you at the coffee shop. Oh, there's the council members again doing business in secret. Is that a violation? The statute expressly does not apply to social gatherings or to chance meetings, right? As long as the discussion of public business is not the purpose of that meeting. So it's fine to have coffee together or whatever, you know, those kind of social events, but just be cognizant of the fact that those cannot morph into discussions of city business. So if you bump into each other at the coffee shop, that is not the time, if 3 or more are there, to say, oh, did you look at the packet? What do you think of that budget amendment that the manager is proposing? And you start talking about the merits. That would be improper under the open meetings law. Okay, let's dig down a layer deeper. The statute says that a meeting includes any kind of gathering to discuss public business, whether in person like we're doing now, by phone, or by electronic means, such as like we're doing now, this hybrid meeting over Zoom. That phrase electronically was actually added to the statute back in 1996 to address the advent of email, back when we were all using Netscape, right? And dial-up internet, right? So it's been a part of the state statute for many, many years that email, right, can and is subject to the open meetings law, right? And so to summarize how you articulate that rule, if 3 or more members of the council use email to discuss public business, that can trigger the openness requirements of the statute. Yes?
Sam, I have concerns or questions about serial emails. I think that there was a school board in the East Range, I think, Eastern Slope, where it was determined that serial emails, a meeting decision had been made, and that was only rubber stamped at a meeting. So how does open meetings apply to serial emails?
Yeah, I think there's a building body of case law that basically says this, to keep it simple. If the evidence comes in a claims context, that it appears that what occurred in the open public meeting was a mere rubber stamping of a decision that was reached outside of, right, a public meeting, then the courts are going to potentially invalidate that, right? There are a lot of phrases for this. As I mentioned, the statute's a rule of 3. The openness requirement is triggered whenever 3 or more. So the city attorney will correct me here if you got a different view on it. So it's a rule of 3. That must mean a one-on-one meeting's okay, right? But as you hit it on, okay, well, 3, the openness rule is triggered. One-on-one's okay, but what do we think about one-on-one? A lot of different names for it. Serial meeting, daisy chain meeting. In Texas, they call it a walk-in quorum, okay? All of those things, again, I think there's a building body of case law that says, look, if that's what's really going on, if elected officials with the intent of doing so are using one-on-one meetings to evade, right, the purpose of the open meetings law, which is that the formation of public policy occur in public meetings, then there's a risk that the court's going to ding you for that, okay? Yeah. Okay. There's also, I think, a need to, we want to commit to self-regulate on these issues, because there's always the risk the legislature will write the cure for this perceived problem, and it could be pretty heavy-handed. In Texas, they do have, our statute doesn't directly take on the issue, but in Texas, they do have a walk-in quorum statute. And what they said in their legislation that was passed a number of years ago, it says that if elected officials with the intent of evading the openness requirement of the open meetings law down there engage in one-on-one meetings to take a decision or to take a policy, then that's not only contrary to the statute, it's a violation of the open meetings law, but it's a misdemeanor, which is pretty heavy-handed for a state like Texas, right? So yes, there was, I think you may be hinting at the Douglas County School Board case. And there have been other ones that have bubbled up. What I'm concerned about is, that kind of one-off incident ends up being the tail that wags the dog to some heavy-handed legislative fix. But we have to walk the walk. We have to self-regulate and recognize that if one email goes to another and it's like, what do you think of this issue? And then somebody else gets pulled into that email thread, we ought not to be doing that, right? Getting back out of the weeds up to the 40,000-foot level, the statute says at the very beginning that the purpose of the open meetings law, and it says that it's the public policy of the state of Colorado and a matter of statewide concern that the formation of public policy is public business and shall not be conducted in secret. So the idea there is the intent of the statute is to give people an early window into the reasoning for your decision. So that's why you want to have full deliberations on issues. We have some claims, and you may have seen some in the news recently. This plugs right into the perception that there's a problem. Doesn't have to do with one-on-one, but has to do with executive sessions. If a governing body adjourns from back into open session from an executive session, and they just immediately pass a motion, there might ultimately be no liability. But the perception issue that's being created, people are wondering, well, where and when was this issue discussed, right? Did they improperly take an action in executive session, or did they improperly agree upon what their position would be outside of the meeting, whether in person or by email, okay? Now, having said that, email is a great tool for some things, right? And the handout talks a little bit about that. In fact, the legislature added that phrase in 1996. They didn't get around until, I think it was 2001, right? 25 years later, they finally got around to some legislative clarification of where the safe harbors are in the use of email, right? They said that if the email is not used to discuss the merits or substance of pending legislation or pending policy matters, right, then that's probably going to be okay. But more directly, they said, if the emails, even if all 5 of you are on the email thread, if the emails only concern scheduling and availability, or posing a question for discussion at your public meeting, or FYIs, or copying your fellow council members when you respond back to a constituent, those are all considered non-meetings, and all of that's fine, okay? I'll give you one last thought on that. Where the rubber hits the road from a claims management perspective is what we see. Where do these issues most commonly come up? When there's a controversial decision. And what usually happens is after the decision is made, there's often a CoA request, a public records request. And it's because citizens are genuinely interested in good faith to find out whether there were other discussions about this issue. Hey, I want more insight into, this was a hard decision for our community. I want more insight into whether there were any emails between the council members or any emails between council and staff about the issue, so that I can, and we're obligated under the open records law to provide those emails if they qualify as a public record. Sometimes in the risk world, what we see is people get those emails, they're just looking for insights on the decision-making process, then they start reading the to and from lines, and they look at it and they go, wait a second, this thread appears to be an email thread among 3 or more members talking about a matter of public business, should that not have occurred in an open public meeting? So that's where all the action is around these issues in terms of claims that we see. Okay. Other questions about that? Yeah, staff probably has tools for you, and you probably have been habituated to these, where maybe Sarah is saying, please do not hit reply all, right? To ensure compliance with the open meetings law, and that's a good way to do that, right? Other things in terms of managing the CoA side of this, I don't have this in my slides, but when we do get, if your custodian of records does get a request and it says, I hereby request all city documents relating to that decision, including the packet, the minutes, any emails from staff, and any emails by or among the council members, then there's an obligation, right, to amass that material, right, look at whether it's within the scope of the request, then vet it to determine whether any privileges or exclusions apply, and then produce the emails that need to be produced. So whatever it looks like to you, maybe staff has or will do more training with you all on that. Have an efficient process for doing that. If it is your piece of correspondence, then yes, the custodian will, consult with you on whether or not this correspondence needs to be disclosed, but it needs prompt attention. We don't, in a claims context, want to find way down the road that there was some piece of correspondence that wasn't properly disclosed earlier that has some influence on the matter that we didn't know about it. And frankly, there's a faith and trust issue, right? If the CoA requests are not handled appropriately when they're filed, right? If something comes up later that should have been disclosed. Yes?
Could you please address text messaging in that context as well?
So I don't think we have a reported appellate case, but when it says that if a meeting is any kind of gathering, whether in person, by phone, or electronically, what do you think? Is texting same as email? Yeah, in general, I think so. There has been litigation around this issue about whether texts are actually made, maintained, and kept in an official capacity, and so there's disputes around that issue that may influence the issue. But in my view, if the text concerns performance of your duties as an elected official or relates to public funds, then in using text to communicate with staff or each other, you're generating a record that is subject to the open records law, okay? Now, on the other side of that issue, recognize that text, you want to follow your records retention schedule, right? And texts are usually kind of just ephemeral communications. And I don't know what your records retention schedule is, but if it's just a temporary transitory communication, you don't have to keep that stuff forever. If you want to, that's fine. Just recognize if you get a CoA request, you're going to have to go through all those and probably take screenshots, right? Has that been the practice? Yeah. Take a screenshot, send it to the right staff person. Okay, one other thing on texting, this is both a legal issue and frankly kind of a bad look. If you're in a quasi-judicial proceeding, right, we've had, I think, 3 sets of allegations around these issues. You shouldn't be texting each other at the dais. Because the odd sort of thing is, isn't that from one perspective potentially a meeting, right, within a meeting? It's like a secret meeting within a public meeting, right? Now, if it's just an email, from the mayor pro tem to the mayor that says, Mayor, you forgot to open the hearing. Hey, somebody technically could get that under the open records. It's only 2 people, so it's not an open meetings violation. But what I'm, concerned about is tough decision. People in the room are, emotions are high. No matter how you vote on this land development or what, people are going to be upset. But people are texting about how they're going to vote, right? It shouldn't be doing that kind of thing within the quasi-judicial context. You should have your deliberations on the record. I'm sympathetic in this day and age that sometimes it feels vulnerable, right? It's a tough decision, and whatever I say, I'm going to make someone unhappy, but the public meetings law requires that we have our deliberations so that citizens can observe them. Yes?
Yes, executive session, use of cell phones and emails during executive sessions.
I don't know, Jim, if you have thoughts on this, or whether this is a live issue, but I haven't seen it much because it doesn't happen much. I guess my view on risk management is it ought not to happen much, if at all. There shouldn't be emailing from persons inside doing executive session to people outside the executive session if it relates to the substance of the executive session. Right. That's not honoring confidentiality in my personal view. Now, there may be more nuances I don't know about. This might be a live one for what you want Jim's advice, right? But getting a little bit off track with regard to confidentiality in executive sessions, as fiduciaries, right, we're each individually obligated to honor the confidentiality as identified by the group, right? And that's true even if we voted against going into executive session, or even if we can't stand the idea of the underlying transaction or whatever it is being discussed in executive session. As fiduciaries, we have an obligation to protect the confidential information belonging to the city in this scenario as identified by the council. Easy way, I hope, to get on the same page about that is before you adjourn out of executive session, might be the mayor or who's ever presenting, we say of all the confidential information that we've talked about in executive session, which information, if any, leaves this room and who's our spokesperson. And that just, we've magically all gotten on the same page about what, if any, information can be shared from this executive session. On the tail end of that, there's another thing you can do to build faith and trust among your citizens, because they may wonder, well, why are they in executive session, right? But citizens in good faith know that if you're using executive sessions sparingly, only on an as-needed basis, that you're doing that to protect the interest of the city, right? Or to protect your position in a negotiation in the best interest of the city. But sometimes, like on matters subject to negotiation, you can come out of executive session and maybe it's staff or the mayor says something like, we affirm to the people, hey, executive session's over, just want to confirm it was for discussion of a matter subject to negotiation. Want to let everybody know that if our negotiations get some traction, there can and will be a future public meeting agenda item upon, at which there'll be an opportunity for public comment. So we appreciate everyone bearing with us while we held the executive session. So if you have other thoughts you'd like to add around these issues? Okay. Any other questions on that stuff? Lastly, on documents, just for the new folks, when the city attorney's office, that the fiduciary obligation also extends to protecting confidential documents. If it comes from Jim's office, is it red stamp, big red stamp, attorney-client communication. So that's pretty easy to identify. But once in a while, your city manager might send you something separate from the packet. And it's like, for your eyes only. There are no silly questions in that regard, particularly for the new folks. If you're wondering, well, why did this document come this way? And is this for my eyes only? Maybe it's a confidential appraisal, or maybe it's a strange thing called work product. Right, which is protected under the law. Always that call to your manager to say, what is this document and how are we to handle it, is always an appropriate question. So, okay. All right. Here's a question. Do we use social media to do our job as an elected official? Any of us? Maybe, maybe not. Okay, well, I forgot to mention, by the way, at the outset, one of my handouts at Put Your Places with our Ethics, Liability, and Best Practices Handbook. There's a chapter in there about social media. I would just suggest take a look at that. But there is breaking news on social media. The Supreme Court on Friday issued a decision about liability aspects of public officials' use of social media. And the question the Supreme Court considered what they issued their opinion on last Friday was the question of whether or not a public official can block or remove content from a social media thread if the public official doesn't like the comment or doesn't like the commenter, right? You know how it is. You might use social media to put out a positive message, right? Hey, we got a wonderful event, food and wine festival coming up this week. Here's where you can go to see more about that. And the first comment in the thread is, you're all crooks and liars and I can't stand local government. There's kind of a temptation to say, well, can I get rid of that? If it's on my personal, so can I delete that comment? So the Supreme Court issued some new standards on that last week that are going to influence the liability analysis on that. And it's actually, based on their opinion, it's going to be a narrower road for a plaintiff to prove liability if a public official removes or blocks them on social media, but I still have kind of about the same risk management suggestion, and that is if you're gonna have a social media site and you're gonna use it in a way that might be related to your job as a public official, then just resist the temptation to block or remove people based on the content of what they're saying, because you're all governmental actors for purposes of potential First Amendment liability. So I'll leave it there, but if you have questions in the moment about live situations, you can talk with the city attorney. My comforting thought, I hope, on this issue is it is disheartening, some of the stuff that's occurring on social media, right? But recognize that, do you agree that public officials sometimes can be on the receiving end of less than courteous things on social media? My last check, there are more than 500 billion social media posts every day. So, today's post is going to be yesterday's news before we even get to the end of today. And so some of that stuff is just letting it roll off, and it too will pass. And that's probably, from a risk management perspective, still a better way to look at that than trying to block or censor content. Now, there are changes in the law on that as of last Friday, but that's just kind of my takeaway on social media. Yeah. Any questions, thoughts on social media, email, texting? Anything else? All right. What are we doing time-wise? Let's pivot here and just talk briefly about organizational structure. I've talked about this in the past, but particularly for the new folks, and the reminder is there is the risk when you're an elected local government official, there is a risk, and it's a fair question to your city attorney as to, is there the possibility that in this job as a council member, I could get sued and be held individually and personally liable for something that I do as an elected official? I hope it doesn't keep you up at night. Please don't let it, right? But the risk is there. So I just want to, again, go over real quickly what the protection is and what the boundaries of that protection are, okay? So the good news is in Colorado, we have a statute, the Colorado Governmental Immunity Act, right? That says the city, and by extension, its insurance company, CIRSA, will defend you and will pay judgments entered against you for acts or omissions as a council member. Good news. Like so many things in life, there's a catch to that, or there's conditions to that. Those protections apply so long as we're acting within the scope of our employment and not acting willfully and wantonly. The scope of employment phrase sounds a little bit odd to an elected official because you're thinking, wait a second, I'm not an employee like the city manager or others at the city. I'm an elected official. But in terms of the liability analysis, it's all the same thing. The statute uses the phrase scope of employment. And it simply means understanding and honoring what is your authority, and as important, understanding what authority you don't have, right? So this idea of allocation of authority, delegation of authority permeates every municipal organization, right? Just a very simple example, and then I'll move on real quickly. You all have short-term rental licenses, don't you? Yeah, I think you do. So, and they're handled by, the licensing determinations are made by the staff. Right, is that the city clerk? It's actually our community development director. Right, so, yeah, all right, I didn't bring an application with me. Yeah, but this, just to illustrate the scope of employment concept, within whose scope of employment, within whose job description, within our organizational structure, by choice of the council, within whose scope of employment, is it to decide whether or not someone gets a short-term rental license? Right? So within whose scope of employment ain't it? Well, and everybody else, right? So organizations that are firing on all cylinders and effectively managing risk on this area, everyone is kind of staying within their lane, but we're working together to move the organization forward, but we understand what authority we don't have, right? So that's scope of employment. I'll touch a little bit more on how that risk presents itself in just a second. The other is you're protected as long as you're not engaging in willful and wanton conduct, which is just a fancy phrase for conduct that's intentionally undertaken, designed to injure someone's legal rights, and taken with reckless disregard for what their rights are. It's almost like conduct that has like an evil motive behind it, right? It's like bad, I call it bad stuff, and it really would be. We don't get many claims around that involving elected or appointed officials, but here is the situation where we see that type of claim. It's usually an allegation, right, that is almost always an allegation that an individual elected or appointed official or employee acting individually, right, misperceiving that they have some governmental authority that they actually don't have, right, throwing on that purported cloak of governmental authority and doing bad things to people for the wrong reasons. And it really would be bad stuff. As give you an example from claims we've had, it would be, for example, an appointed official not thinking of things rightly, conscripting, my apologies, but I'll continue with the STR, conscripting a staff member and who also begins not thinking about things the right way and goes on a campaign to make sure that the short-term rental license of a political enemy gets revoked, or that their business competitor doesn't get a business license or doesn't get a building permit, or intentionally defaming someone with a statement that we know is false, right? Or attempting to interfere with someone's business opportunities. That's a tort in Colorado. Those are malicious conduct. Even misusing the cloak of governmental authority to engage in a criminal act. All of those things are bad stuff for which the protections don't apply. And similarly, the insurance does not apply because public officials' liability coverage has exceptions for that kind of conduct as well. So I don't want to end on kind of a dour note about that. You know, conversely, yes, we need to understand where the limits of the protection are, but conversely, don't let the fear of liability drive decision-making. You know, sometimes you're going to make a tough, I don't know, land development decision. If the applicant, you know, you get, all the evidence points to denial, and you've had your discussion, and, you know, you're about to adopt a motion for denial, don't stray the course just because the person says, you know, counsel, if you do that, I'm going to sue each and every one of you individually. That's what these protections and insurance are for, to protect you in that situation. If we know we're making the right decision through a fair and defensible process, applying the correct legally defensible standards, you're going to be just fine in the face of those kinds of threats, okay? All right, any questions about that piece? That was about state law. You got similar protections under federal law. The concept of qualified immunity, you've all heard or read about that. We usually read about it in the police context. Qualified immunity is a protection that applies to all government actors. Basically says that you have protection from liability under federal law as long as you are not violating the federally protected rights of a person that you knew or should have known about. That last phrase is kind of interesting, right? Knew or should have known. So the crux is, well, how do I know? Right? And that's what your staff is there to support you. So again, if you ever have a question, you're feeling uneasy, you know, just you have that conversation with your city attorney. What's our authority in this area? What are the pros and cons? You do have to give Jim and his team some grace, and I used to be a municipal attorney for a long time. Sometimes the answer truly is, good lawyer answer, it depends. Because it does. It does, particularly in the area of federal civil rights liability, it is highly fact sensitive, right? But it's always your prerogative that conversation with your staff and attorney about what are the pros and cons, what's our authority, what are the risks, so that you're well informed on decisions that you're going to make in that regard, okay? There's a couple tips on this slide, things that we've hit on already about managing risk around role discipline. I think it all, at a 40,000 foot level, just goes back to the idea of understanding as the elected governing body, what's my role, what's my job description. I think it says right in your charter that your primary job is to be the legislative and the governing body of the organization, the policy-making arm. That part of the organization that has the broadest interest in mind, right? The most important documents for you are not the details of an STR application. They're things like the annual budget, the master plan, the long-term plans for the community as a whole, thinking about and discussing where do we want the community to be in 5, 10 years, supervising your direct reports, right, and dealing with quasi-judicial matters that are reserved to the council. But you want to think in terms of this hierarchical structure of your role in your job protection, your scope of employment is in those upper tiers, the ownership and governance aspects of the organization, okay? Finally, last thought on this is to recognize that role discipline is particularly important in the area of administrative matters and employee relations, right? We all recognize that the city council, right, that elected officials, except for your few direct reports, that elected officials are not employee supervisors. You do have a couple of direct reports, but they are limited to the manager, the attorney, the judge. That's it. What a wonderful place to be from a risk management standpoint. Because employment practices liability gets more complex every legislative session for sure, if not every day, with all the things going around that, right? And so if we appreciate the fact that all responsibility for personnel and administrative matters have been delegated to the manager and her staff, that protects you. Right? That allocation of responsibility protects and serves you. Once in a while, we'll have a claim an employment practices claim where the overzealous plaintiff tries to name an elected or appointed official. Well, if they have no factual basis for that, and if the elected officials are appreciating and respecting the fact that the manager and her team take all that risk, right, then that's an easy way for us to go back to the plaintiff and say, look, you have no fact. If you look at our org chart, the manager and the supervisors are responsible for personnel issues, not the elected officials, so they're not a proper party to this litigation, okay? This concept is even enshrined in your charter. There's a section in there about the relationship of council to the administrative service of the organization. You want to take a look at that. It's not that they're siloed, right? But what it says is that the council's relationship to the administrative service shall solely be with and through the manager, right? So, but I'm not naive. I was a city attorney for a long time. What happens is maybe every once in a while someone comes to you with a citizen. They got a concern about an employee who isn't one of your 3 direct reports. What do you want to do with that? You want to pass that off to your manager? And just like that other lawyer response, right? You want to respect the response when Sarah says, I got it. We'll take care of it. It's an administrative or personnel matter. We'll take care of that. Yeah, sometimes there's really high-profile things that might have hair and warts on them where the manager is going to, give you a little bit of communication to keep you in the know on a need-to-know basis. But that's not to say that council has a role in deciding the personnel matter that's high-profile. It's just to make sure we have our communication flow down, right? Sometimes, hey, you may get a citizen inquiry, a citizen may approach you about this issue. If that comes up, our spokespeople, their point of contact is the manager or what have you, okay? It's a wonderful place to be from a risk management perspective because you can unburden yourself from having to manage that risk and say, my city manager and her team, they'll take care of that. They're responsive to the needs of the organization and the employees, and they'll appropriately handle matters that arise in that regard. Okay? Use your city manager as your resource and point of contact. Support good information flow around those issues. Okay. Any thoughts or questions around that? Let's see. Last thing I want to talk about with regard to organizational and structure liability is each member of the council, right, brings its own perspectives, experiences, et cetera. But in doing so, it's a multi-member governing body that ultimately is expressing the council's voice with one voice, right? And sometimes I guess what that means is the job requires some personal sacrifices. Right, a couple of them I've listed here, in terms of strengthening the governing body as an institution. If you think about it, right, being in a municipal organization, serving on a city council, municipal work is kind of like a train. We all want that train to get to its destination, whatever that is for our community. We want to move our community forward. And during our term of office, we get on and off that train and contribute. We want to make that engine stronger. But it does require some personal sacrifices, I think, that strengthen the voice of the council. Things like setting aside a personal interest or an agenda when there's a lack of support. Right? Even it can be frustrating sometimes, even if you may have the view, well, I sought election or I was elected to get this ordinance passed. But if there's not at least 2 other members of the council that are willing to come along, or if it's not in the work plan, then we have to be willing to set aside that personal interest or agenda in view of service of the work plan of the council as determined by the council. Do you ever have split votes, Mayor?
Occasionally.
Occasionally. What if you have a 3-2 vote and you're on the 2 side? Can you go back to your people, the ones you take counsel from, and can you go back to them and say, I didn't vote for that one? Absolutely. Absolutely you can. Well, I'm just the insurance guy, Far be it from me to tell you what you can tell you people. You tell them whatever you want. But they already knew how you voted, right? Because that's part of the public record. Right? But in terms of strengthening the council as an institution, right? Because we'll probably all win some and lose some. Do we make the council stronger if the message was, I didn't vote for that one, but you know what? We had a vigorous debate at council. We had a lot of differing opinions. I fought like heck from my point of view. But you know what? Council decided to go a different direction, and I respect the decision of council. Yeah, you don't have to be the primary cheerleader of the decision that would reach, but in that fiduciary context, from a risk management perspective, my view is you certainly can't do things that actively undermine the decision. I'll give you a kind of an interesting scenario on that. I had a split vote on a development matter, and the council, very vigorous discussion about whether or not to approve the development. The council finally got to a majority in favor of approval when they said, we'll approve, but one condition of approval is you need to go to the neighbor and get an additional access easement. So we've got a secondary access. Split vote, 4-3 vote. After that decision was made, somebody on the 3 side went to the next door neighbor and did what? Told him not to grant the easement. Being an elected official is a 24/7 job sometimes. And in that risk scenario, right, the concern was that was a member of the governing body that spoke with that one voice, now attempting to, what I was worried about for that official was, are they potentially tortiously interfering with something? Like the council the night before said, hey, as an organization, we'll allow you to proceed as long as you meet this condition. Now we have our own members doing something that's attempting to undo that. That doesn't mean you can't revisit the decision, but if you ever have that desire to do so, you want to consult closely with staff and say, what are our, are there rules around reconsideration? There absolutely are. Is it true that certain decisions cannot be undone? Yes, right? So you want to make sure you have a good understanding of what the rules are around that, okay? Recognize that individual efforts, Mayor, do members get appointed as liaisons to boards and commissions? Yeah, that liaison role is still in service of the council as a whole, right? Those kinds of roles are typically serving as a conduit to help relay the council's view of an issue, to support the relationship between the two entities as entities. And then one that people call me about that I put in the last bullet here is I get more calls about this, particularly with social media. I don't know if I should be the one fielding the calls. I usually deflect them back to their own manager or staff or administrator for thoughts. But some people call me because they're asking, isn't there a state statute that deals with this problem? And that's the idea of, do we have perceptions or reality where individual members are either getting ahead of or purporting to speak for the voice of council before the council has spoken, right? And that's that balance between each and every member of a multi-member governing body, yes, has a right to their personal opinion and their own views, but in terms of thinking about the impacts to the council as an institution, I think it's a wise body where its members both individually and collectively are eyes up on the issue of, are we getting ahead of each other? Are we putting each other in an awkward spot where we're purporting to speak, because citizens always are we purporting to speak for the body before the body itself has spoken? Yes.
2 things, if I can remember both of them. One of them is that in our oath of office, we swear to protect the Constitution of the United States, the Constitution of Colorado, and the ordinances of the city of Aspen. So as new members come on board, their responsibility is to act as one voice in regard to ordinance that were enacted prior to their sitting on the board. Is that correct?
Well, if there's a view, if it's a legislative matter and there's been a change and the legislative body decides by whatever process you have to take up that legislation again, unless you have some lockout provision for initiated or referred ordinances, the legislative body can always look at legislation, and legislation is living, right? So if there's a shift, the legislative body, if they so desire, can look at some prior ordinance and say, oh, that nuisance ordinance that was adopted in 2018, do we as council want to take a new look at it? Right, and individuals from adding their own voice to the deliberation absolutely can contribute the voice that says, yeah, I'd like to take a look at it, right?
My second question is if you give us high level between statutory and home rule municipalities and what powers we have as a home rule municipality as it relates to legislation from the state.
Okay, I'll try. I want to give one scenario running the other direction on that, decisions that can't be revisited. certain decisions, as I said, can't be undone without liability. So you have a change of membership and different view of the majority, you can't come in and say, well, I'd like to repeal that bond ordinance where we borrowed the money already and spent the money, right? That kind of thing. Certain obligations become irrevocable, right, without risk of liability. So on the home rule versus statutory, so being home rule, you have more control over matters of local concern, and you have the ability to adopt legislation in areas of mixed concern, which is a stronger power than a statutory municipality has. It may be in areas such as potentially land use or taxation or organizational structure, those kinds of things. But you are home rule, right? Which means if you have a question of, look, we know the state law says this, but do we as a council, do we have authority to legislate either in a manner that's complementary or contrary to the state statute? I know a great place to send that question, and that's to your city attorney, because it's been a long time since I've really gotten in the trenches on that stuff. But the big topics, you know, that either have come up recently or are going to come up are land use, right, around the things that the governor and legislature are doing around land use control. Oil and gas was a big one a couple of years back. Housing as well, those issues, there's probably a couple more that I'm forgetting. Yeah. So I hope that helps. Wasn't much, but I hope it helps. Okay. I know I need to catch up on time, so I'm just going to go through the rest of the material quickly. I did want to, sometimes the question is, all right, so in practical terms, where do our big risks lie as a governing body, either in terms of individual or collective liability? So on this slide, I listed them. These are the typical types of claims where we see the governing body, either as a governing body or the members of the governing body named as parties, most often just in their official capacity. Two of the bullets, bullet number 3 and bullet number 4, willful and wanton conduct or tortious intentional torts or breach of ethics or fiduciary duties, those are the ones where we would see allegations against people in their individual capacity. Or under federal law, if it was in some extreme situation where an elected or appointed official went rogue and individually was violating people's civil rights, we might see them individually named in a civil rights context. But typically, most civil rights claims where the council's involved, they're trying to bring an entity claim against the city. Okay, so there's a list of things there. Let's see. Yep. I think I'm down to my final thoughts, if I've got that right. Oh, I did want to make a comment or two. I promised to make a comment or two about law enforcement liability, just so you're aware of what's going on in our world. So you know from the papers, right, that law enforcement liability has been a significant issue. You probably know from your reinsurance renewal that the costs of law enforcement liability insurance coverage is increasing, right? Our members typically for between 2023 and 2024 saw an increase of 150% or maybe doubling of their premiums for law enforcement. This is all a reflection of the fact that both in Colorado and around the country, there is a rising trend towards larger verdicts and settlement. There is a concept of social inflation influencing verdicts and settlements, and that is being reflected both in Colorado and nationally in the cost of law enforcement liability coverage. We at CIRSA are doing everything we can to try and control those costs. We are fortunate to have good reinsurers on our program for liability that are actually pools of pools. In other words, they reinsure governmental pools, so they understand the law enforcement liability risk and are not afraid of the risk, but they have to price appropriately. So we just want to point out that the pricing on that is increasing, is intended to increase. In addition to rates, our board of directors is looking at how we might further fairly distribute the cost of that risk. Okay, so our board, for example, has been looking at the concepts of changes in deductibles for law enforcement coverages and other coverages to help even more fairly allocate the cost of these risks among our membership. So there'll be more news on that issue coming as well. Getting out of the weeds a little bit, I guess what that means at the governing body level is we decide, right, as a community that we want policing, and it's just going to be the inevitable fact of life that we want to make sure we're adequately resourcing law enforcement. Well, you'll have to do it on the insurance side to carry the insurance, but also on the risk management side, okay? And I'm going to leave with staff. Your chief was a co-presenter with us last year down at a presentation that we did for the ski towns in Carbondale. We have a wonderful relationship there. We have all sorts of resources for the police department that I'll leave with staff, including our schedule of all the law enforcement events that we have going on this year. So we're doing everything we can to kind of keep rates down. As a municipal community, we need to do everything we can to embrace appropriate risk management around policing and help set, right, proper relationships with the community around policing as a supportive, important, useful service to our membership and to our communities, okay? All right, a couple concluding thoughts. So I've been with CIRSA now about 5 years. Before that, as I said, I was a municipal attorney, and I've learned kind of in the last 5 years, do you agree with the sentiment? There's kind of certain aspects of risk management that we can't control, right? You know, what the jury might do, what the plaintiff might do, what the legislature might do, what public perceptions are. But I do think in the areas that we can control, you know, it's a wise organization, wise leadership that commits to, you know, trying to control areas around risk management that we can control. For governing bodies, getting back down into some particular suggestions, you know, what does that look like in terms of wise leadership? Committing to a no surprises approach, for example. You know, your meetings ought not to have gotcha moments. They certainly ought not to have staff bashing. You know? Imagine how powerful it is if someone during public comment stood up and made a personal attack, right, on a staff member. How powerful it would be to tell that person, you know, our council meetings are not, even if you had a concern about that staff situation, you would deflect that to your manager. Dealing effectively with discord, you know, agreeing to have disagreements without being disagreeable, committing to civility and mutual respect, effectively avoiding high conflict. I put this next bullet on here because who agrees with the sentiment that a lot of what we see in the press is kind of negative press around what local governments are doing, right? But I think particularly at the leadership level, it is part of the job to tout your own successes. Tout the success of the council as a council, of the city as a city, as your staff. Lets people know that your government is getting good things done. Why do I say it as the insurance person? Because I do ultimately think it does influence public perceptions and even maybe jury pools about governments and the great things that local governments are doing. So I think touting your successes is an important aspect of that. And finally, committing to the service of the city as an entity, to the governing body as a living institution, and embracing those stewardship and fiduciary aspects will go a long way in effectively managing your risk. So with that, Mayor and Council, thanks very, very much for having me up. There's some more resources on the following slides, and together with the handouts and just a little bit more about CIRSA. And I apologize, I've run over my time. If you're so inclined, I'm happy to take questions, but I know I'm kind of over my time budget. So.
Any questions at this time from council members?
Thank you.
Are there any areas that council members are interested in more information going forward? Is there anything that maybe you're interested in touching on beyond what this presentation involved?
Thanks for asking. I'd be interested in understanding transparency requirements by staff to the community and to the council members.
Okay.
We can do that separately.
Okay.
Is there any information on that topic that's published from CIRSA? Is there some resource or reference that he could get some information around that?
You know, I think we talk general. I have to think about whether, you know, we do plenty of publications on what Open Records Act requires, what Open Meetings Law requires. You know, my broad risk management theme is in terms of whatever the resourcing, consistent with whatever resources you have, whether it's at the governing body, staff level, you know, do the things that make information available about what your organization is doing, and your citizens will appreciate that, right? Whether it's stuff that staff put up on your behalf on the website, right? Or if it's explanations of why things are being done, that's helpful to the community. It helps build faith and trust, right? So I don't know if you've got pending issues going on, but if, I'll give you an example. Sometimes there's a lot of what we do is born out of controversial issues, right? That you deal with. If there's a high-profile issue that's coming up, you know, and probably your staff is already doing this, like a high-profile issue coming up, there's a lot of questions, but maybe it's not issues that council can handle, because maybe it's quasi-judicial, it's a development application or something. Have we decided, maybe, do we have an FAQ on the website? Or do we have some place where people can go to get most of the common question answered about that, right? In terms of in between council and staff, I guess I'd have to understand more about what is the desire and what's the need, right? And council, as a council, should always have that conversation with staff about what information flow do we want, right? How much is what we want in terms of packets? How much is too much? How do we want things structured and presented and styled, right? And I've seen that discussion go on many, many times, but if you're talking about that level, right, it's the question of checking in with staff of, you know, why do we do our packets this way? Are we getting too much, too little? Do we want more? Is there something we're not getting? Classic issues that I've seen is some councils, governing bodies will say, well, we want the staff report, but we don't want recommendations. Others will say exactly opposite. We do want the staff report, and we want not only recommendations, we want options, and we want pros and cons for each. So for every organization, there's a aspect around that, right, that needs to be a discussion, between the governing body and staff about what that looks like.
Yeah, I understand that. As a baseline, I'd like to understand what the requirements are for information to be shared with.
City staff is required to follow the same open records meetings laws. As was indicated in the presentation, that there is certain information that is work product or privileged of which the council may receive as part of that process, that the general public is not available to review. This is a live issue based on a request Councilor Guth made to me today, so I'd suggest we punt this to legal.
Not necessarily. I disagree.
Okay.
Yeah, we as a council, in our quasi-judicial hats, deal with appeals, and those appeals sometimes can be appealed.
Right.
Our decision can be appealed.
Right.
So I want as much information as I can for proper procedure to protect us from ex parte communications that might be for pending cases or cases that may be under appeal, open cases.
Right.
And disqualifying a member of a governing body because of ex parte communications.
So we do a separate training, and maybe your staff does that for you as well. But if you'd like SORSA to do it, we do a separate training on quasi-judicial proceedings. And we cover not only ex parte communications, but the whole aspect of different rules that apply when you're in that mode. So just one comment here is to remember that if you're making decisions affecting someone's property rights, like a land use application, then you're the quasi-judicial judges, the five people who get to make that decision. And you want that power, but that's, it's pretty awesome power. And with it, when we're making that decision that affects individual property rights, right, we all know where it comes from. No person shall be deprived of life, liberty, or property without due process of law. So that's why there's this whole set of additional rules, additional layers that require that we don't engage with the applicant or the objectors or the proponents outside of the hearing. You want to respect that process. And also in terms of the flow of the process, let the Planning Commission do their work. Stay away from that process. You created them for a reason. Let them do the heavy lift. We don't want to reach down and get involved in a quasi-judicial process. Wait till it's ripe. That's part of the grand bargain. When it's ripe, then there'll be 5 people left who get to make that decision. But if we're going to have 5 people in the game, you have to make sure that up until that point, they've conducted themselves appropriately as judicial officers, essentially, and not engaged in outside the hearing communications or done anything that shows that they're not going to be impartial or that they're biased, right? Those kinds of things. But we do a separate training on that.
Do you have one of these on that?
There's not much about that in that handbook, but at www.sursa.org, we have a couple of trainings posted there.
Thank you.
Yep.
Sam, I just want to say thank you. You know, I've been fortunate to be the recipient of this presentation as well as some others. I think oftentimes a lot of the points that you bring up can be taken as things that should be known, but in my experience, they're not often or not always followed. So I think it's always great to have these reminders. And the last thing I'd say is it's interesting that because your presentation comes from a risk management perspective, it also shouldn't be lost that these are also tips and clues towards best practices as well. This isn't just protecting your downside, but this is also some great comments on how to maximize your upside and your efficiency and your effectiveness. So I appreciate this, and like I say, I've seen it several times, so it's always just a good reminder for me. It's amazing how often so many of the points that you bring up just in today's conversation are relevant on a weekly basis to us. On a weekly basis, we're dealing with 4, 5 of these issues. So it's nonstop, and it's something that we're all learning to be better about as we, it's somewhat of a new world every week. And as you said, just a new Supreme Court ruling last Friday that involves one of the topics here. So I think it's something that we all should pay attention to and stay vigilant in and use as good guidance. So I appreciate your presence here. Thank you so much.
Thank you.
John?
Yeah, I also want to say thanks, Sam. Every time I listen to your presentation, I get something more out of it. And I think not only can this help our council work better together, but I think it can help everybody work better together. Thanks.
Thank you.
Thank you, Sam.
Thanks.
Thanks.
Thank you.
All right, I will queue up another presentation.
Yeah, our next agenda item for this evening's work session is the boards and commissions expectations. There's a lot to this conversation. We have a few items, and really, again, sticking on policy perspective from council, what we're really going to be looking for tonight is to understand current state of boards and commissions, maybe sharing some of our collective expectations, and then what it takes for us to get to that. If you went through the memo, you'll see that there's a lot to this, and there's not a whole bunch that is currently codified in the city of Aspen. And I think, again, efficiency and effectiveness can be enhanced by us tackling this a little bit. I'll also say that, over the last few years, we always have those opportunities where there's better communication and relationships between council and those boards, and I think that's from both sides. We hear that from the boards as well as council. So looking forward to this conversation, but again, we'll be at a high level as we look to move some of the goals here forward. Thanks, Jen.
So Jen, go ahead and, the mayor is.
Oh, I'm on to
The mayor
the
has
next
called
one,
board
yeah.
and commission, so we will go to just that, and we will come back to the other one. Thanks.
We don't have to. We can finish up with the email suggestions that you have.
I think there's some folks in the audience who are here for boards and commissions, so if it's okay, we can move to that item.
All right, that's fine.
All right. Good evening, Mayor, members of council. Jen Newton, Senior Project Manager for the City Manager's Office. Thank you again for the opportunity to address you. The topics for discussion are related to boards and commission expectations, governance, communication, and specific questions related to hybrid meetings. And as the mayor mentioned, there was a lengthy memo that was included in your packet that went over a number of these items. So I will do the length of the conversation this evening, try to be brief. You have a number of boards and commissions that provide you with information and that also do the work of that quasi judicial action, so like your Planning Commission and your Historic Preservation Commission. There are 15 boards and commissions that are appointed by the City Council, and of those, the majority are appointed by council. So this work session is intended to gather some direction related to some of these items. The first one I'll start with is streamlining for governance. So there's not a single document that provides guidance for boards and commissions or their staff liaisons that addresses best practices for operating these boards. A few of those boards, there is information that's codified in the municipal code. Primarily that is related to those boards that are quasi-judicial. So one of the options for streamlining governance is creating an additional section of the municipal code that provides information regarding boards and commissions. There is a section 204030 of the municipal code that applies to boards and commissions, public bodies, but it could be that all of that information is put into one place as one-stop shopping for information. I will say that the clerk's office has added the enacting ordinances to most of the, or potentially all at this point, of the specific web pages that are related to the boards and commissions. I think that's helpful in having, providing that information to the public so that people can understand what the duties and the makeup of those boards are. But currently today, there isn't one-stop shopping for that information. There's also not a uniform set of bylaws for each of these boards. There are, and I think it was included in your packet, hopefully it was, information about what boards do have bylaws, or in one case a charter, but I don't think that that they're all uniform, and I think that there are other areas where we could, even where there is a current set of bylaws, expand that to provide more clarity around meeting minutes, for example, the expectation that there be meeting minutes, or if you were to direct staff to pursue the idea of having hybrid meetings for all the boards and commissions, we believe that's important to have guidance for hybrid meetings that's in those bylaws. It also could live in the municipal code if you wanted to go down that route. Relating to the charter, there are some specific requirements, as you talked about a week ago, related to the charter for boards and commissions. So permanent boards have specific criteria that's in the charter, and there have been some boards that have been created outside of the charter to allow for some flexibility. For example, having participants, members of those boards who don't live in the corporate boundaries of Aspen. There's also a question about term limits, or whether a member of a board needs to be a qualified elector. Certainly, there are times where you might want to have people who are not citizens participate in a board. And so that's one other area that could be addressed in the charter cleanup that you're talking about more widely. If there are questions, I can answer them, or I can just move on to communications.
Let's take a break.
Okay.
So that was a lot of information. In summary, what we don't see as best practices and how the council is managing its boards and commissions. That's the summary of the staff analysis. And where that comes from is that there is not consistent expectations across your boards about how these boards interact with you, how you expect them to interact with the public, how clear the swim lanes are of what is or is not within their purview as your appointees in that body. And what we're suggesting to you is that it should get cleaned up. This is something that lasts several decades when you clean it up. And it's just the nature of the evolution of the community where a board's been added at a time. And this is the first comprehensive look I can find that's happened, quite frankly, in the last 25 years of all the boards. So overall tonight, what we're seeking is your blessing to go forward with coming back to you with code language to clean this all up. And then that we'll place in there decision points for you about things you need to decide as direction. But we want to create some clarity And once that clarity is created, it's a lot easier for us to train both the staff liaisons and your chairs and your new members when they come on, because it's the same training. There's not an exception here or there. So we just ask for that consideration in all of this. Jen does mention in here the charter. You've talked about that recently, and I think that's another place where we could put on the side recommendations if you ever have a charter review commission for the community, that we would keep those notes available to present some staff perspective of possible any charter adjustments that might be appropriate too.
I'm generally desirous of this happening and supportive of this happening. I do think it's important that we get pretty thoughtful about some of these questions, particularly the requirement for members to be electors or residents. I think that may depend on which board it is, and there may be other criteria for specific boards. For example, CCLC, if that board continues, maybe it's not a residency requirement or a qualified elector requirement. Maybe it's a business presence requirement. You know, you have to own or manage a business in a certain area or within the city limits, something like that. But I think we need to be thoughtful there. I can't answer all these questions or think about all the potential questions tonight, but I am desirous of this. Thanks.
Thanks, Bill. John?
Yeah, I fully support this. It's going to make it easier for staff, it's going to make it easier for council, and it's going to make it easier for people who are applying for boards, and easier for the boards themselves. So, thanks.
Ward, comments here?
Yeah, I think that we should not only have as uniform as possible bylaws, but also norms and behaviors, not only for the board and city council members, but also for the public and how they deal with boards' behaviors. I think that there have been examples
Bless you.
in abusive behavior for APSHA and some other boards as well. And I'm really interested in House Bill 1168 as well, as how that, when this was, before it was introduced, I think it was CAST or CML that I was in a subcommittee discussing this, and it was, I think that it appears as though this is a non-funded mandate, that we as a city must have these video recordings and have these minutes, but we don't have any funding to add the personnel that we need to do it. I think it's important, and I asked a question before it was introduced, and I didn't see it in the bill, that people should have access to the meetings, but I asked that should they also have access for public comments through a video conferencing platform. So I want to track 1168, particularly as it affects us for additional staffing and IT expertise to supply the level of transparency and availability for particularly those quasi-judicial and rule settings such as HPC and planning and zoning. But to make meetings as uniform and as open to the public as possible.
So, on the policy level, I think you have support from council, strong support from council for doing anything we can for the efficiency and effectiveness of our boards and increased communication. But stronger and more clear guidelines would be helpful for everybody.
Great. So I heard both municipal code changes as well as uniform set of bylaws. So I'll just move on to the next slide, which is around communications, and I will address your questions here in a minute, Ward, related to that legislation that actually will go to committee on Wednesday. So related to communications, we sent out, Darcy Weir in the city manager's office sent out a questionnaire to the chairs and liaisons of your boards and commissions. And I think in general that there is desire to kind of establish those expectations of the boards and commissions related to communication. There were lots of different ideas and they were included in the packet, but check in with city council through work sessions. You've recently had one with the Wheeler Board, regular cadence of information memos, expectations for when council is discussing a topic and wants to provide feedback. There are a number of other ideas. Staff provided a couple related to maybe you have one work session that a year that's devoted to boards and commissions and can hear that work plan, what the board has done and what they're focused on for the next year. And maybe that takes 2 meetings to get it done. You have a lot of boards and commissions, but I do think that there's a desire for that two-way communication, and I think there's also an opportunity, as Sarah mentioned, in the establishment of those bylaws to provide some information related to what are your expectations related to that communication. So you don't necessarily have to answer this tonight. I do have a slide at the end that is asking a question related to communications, but I think that there is a desire for boards and commissions to understand when you would like to hear from them and what are those expectations for focus related to work plan.
Jen, also super supportive of more communication coming from the boards and commissions to council. I don't think that it's realistic for council members to attend boards and commission meetings on a regular basis. So although I understand, having served on CCLC in the past, that it'd be nice to have council members come, now that I'm in this seat, there's already enough meetings. So I don't see that as being the solution, but I do think something like a quarterly report from the assigned staff member and with commentary from the chair would be valuable coming up to all of us, a summary of what you've done in the last quarter, what you're working on in the next quarter. These could be one-pagers. I personally wouldn't want to see more than that, but a quick summary of the various, in the case of HPC or P&Z, the various cases. These are the 6 cases that we worked on. Here were the outcomes, the votes. Here's what's coming up, et cetera. And then a little commentary color, I think, would be helpful for me. Thanks.
Is that the kind of depth of input that you are seeking at this time?
We may ask some more clarifying questions, but in general, we would like to have, I think there's also a question for some of these boards and commissions where there may be the expectation of the board and the work that they're doing today, there's a mismatch for that. So I do have a question at the end that's related to that, and I think it's probably more than we can take on in this setting. So I think hearing from you and then bringing something back is what I would anticipate related to that.
Okay, great.
Yeah, my personal preference would be that we would scatter or not have 1 or 2 meetings, just work sessions with boards, but scatter it out throughout the year so we can, I know when I have a meeting with a bunch of people that all of a sudden they start blending together, so I'd like to be able to keep those differentiated. That's my own personal preference, but we'll come back to that later.
I'm briefly going to touch on hybrid meetings as it relates to this. So there have been requests both from members of the public and members of boards that there be a hybrid option. There's a lengthy analysis of what that looks like and means for staff related to having a situation like this where there's a Zoom room and there are folks who are monitoring that to make sure that people can raise their hand or ask questions at the appropriate times in the context of a land use hearing, that you're getting the information that you need if you do have an appeal, and that there is a proper record. So in terms of hybrid meetings, that's one consideration. There is this House bill that has been introduced in the legislature. I understand that there will be amendments that the authors of that bill have agreed to, but it would still require public meetings of local public bodies to be accessible in real time through live streaming video or audio. There isn't funding that's attached to that bill, but it does have an exemption for the video component in a community where there's not sufficient bandwidth. We obviously have that, so can provide live streaming video. There's other components of the bill about posting documents prior to the meeting, remote participation. So it does allow for people to participate in the hearing, and then the requirement to provide auxiliary aids. So staff believes that this still would require to be a requirement for all boards and commissions where formal action would occur to comply with the law if it is passed, either as introduced or as we anticipate the amendments would appear. So I bring this up because this is one of those areas of statewide concern where we might be preempted and have a requirement. But there, separate and apart from that, there is a conversation that's been happening about hybrid meetings and the desire for that. So I wanted to include that in this conversation. We think it's really important for those bylaws to address what are the requirements. So in a land use hearing that would be our strong recommendation that the chair be in the room. And not trying to have a hybrid meeting where the chair is remote.
Jen, a few thoughts on that. I think this is critical. I'd like to preempt the House bill, whether or not it happens, not vice versa. I'd ask that you look into some third-party services that can help administer the meetings rather than us having to hire a full-time staff member. I imagine that those exist, but I'm certainly no expert on that. Perhaps also use the chair or vice chair of the various boards to help administer the meetings. I don't think these relatively small board and committee meetings are that difficult to administer while you're sitting in them from a technological standpoint. So perhaps muting people and unmuting people when hands are raised could be handled by the board or commission members themselves. Maybe with some assistance from some third-party service that could help fix any technical issues that come up or something that while a meeting's being held. I don't think that GrassRoots needs to be involved. I noticed that in your memo today. I think that this could be either, in this room or some other room and on Zoom, and that's sufficient. Those are my thoughts. Thanks.
And I probably should clarify that the support that we have for the city council meeting, it's really important for there to be that support for other types of quasi-judicial matters. So historic preservation, planning commission, that's where I see the biggest need. I think there are boards and commissions that successfully are able to navigate this where there isn't, that land use component of the conversation. The one, the liquor licensing authority is another one where there might need to be support if that's the desire to move in that direction for if it's for all boards and commissions.
Yeah, I would like this applied equally across all boards and commissions personally.
Bill, question for clarification. If GrassRoots could be that third party that supplies the expertise that we need, when I looked at the memo, the cost of a full-time employee exceeds the cost of what GrassRoots charges for administering our meetings. So if they have the expertise and they come in lower than a full-time employee, would you entertain that?
Sure, I didn't contemplate it because I don't think they provide Zoom services currently, but if they're willing to offer that, why not? Yeah, I understand the need for that support. I think that there are potentially other ways to provide that support than what we do for our council meetings, for example.
And I think it's particular to the room because the cameras are being run by the switcher that GrassRoots runs. We also do have support of IT staff who help set up the Zoom room and make it all talk to each other. So essentially you have two levels of support for a council meeting.
Or two styles of meetings. Perhaps there's another camera that could be basically mounted where you're sitting, Jen, for these other boards and commissions that is, it doesn't zoom in on each individual person's face, but all the sound is captured and there's a wide view of all board or committee members and it accomplishes the same thing. Maybe not everyone looks as good on TV, but.
I look better from a distance.
I think what we hear from this council is support for moving in this direction. We understand the difficulties, but we want to not only adhere to whatever state guidance is going to be coming forward, if state guidance is going to be coming forward. I think that they're struggling with it as well. But this council is a policy direction. We want to continue to work towards that accessibility. I don't think we should get out ahead of this, because I think the work that they're doing, looking into how that they would administer it, will be very informative for us about how we can do it and do it successfully. But I do want to move in this direction. I just think that there's a lot to be done here, and as long as we're working on it and moving towards that direction, then I'm happy about that. John, did you want to put an input on that?
We were just talking about inclusivity and transparency with the public, and I think this helps address that. Thanks.
Thank you.
So the one question that's outstanding here that you haven't already addressed is related to that, if there's areas of focus related to expectation setting for boards and commissions. So I do want to leave open the option to have a conversation about if there's any direction for things that we can bring back related to this. But my understanding is that there are some boards and commissions where you would like for the information to be more directed from the boards and commissions, or them to follow their written direction. So I just wanted to provide this as an opportunity. If there are areas where you'd like to give us some feedback, I do think that there's a number of things that will come back related to this, and we will make some recommendations with specific asks moving forward.
Jen, could you give us some color on what
you know,
some boards are doing that isn't explicitly written in their?
Attendance, term limits, the residency, those are all just basic ones that come to my mind right away.
Staying in your lane.
Yes, the HPC letter that you shared could be a good example of that. Is that right?
Sure. We would anticipate preparing for you some statements around the appropriate or inappropriateness of interacting with the media and how that should be handled at a board and commission level.
Great. So I get, in my mind, I'm sort of thinking this as two parts. There's like the rules and charter, if you will, of each of these boards and commissions, and hopefully we can streamline those. And then there's sort of like, are you doing the work that is expected of you? I think HPC and P&Z, the answer is probably generally yes, because there's specific cases that they're hearing, and it's like you've got to weigh in on those cases. In my personal experience on CCLC, is like there's very little agenda, and there's a lot of wide-ranging discussion on what messaging wants to be brought up to council, which hasn't happened effectively in the past. So that, to me, there's sort of two things that we need to work on. Is one is the rules, and the other is like, what do we want these boards and commissions working on?
So I think what we'll do at the staff level is start on the bylaws and the ordinance change, but it's really up to the council to let me know if you want time to review the purpose of each or any of these boards and commissions, and I would defer that back to the council if there's certain ones you want to review.
I do.
We'll get there in a second. Any other comments or questions right now? Ward?
Yeah, I tend to agree with Bill on communication, that we should get quarterly or timely reports. I think that the email we got from CCLC this afternoon is a good example of the kind of report I'd like to see, what the board has been doing and communicating that to City Council. And I think that there should be well understood expectations both ways, what we expect of the board and what the board expects of us.
A question for you. Currently, 15 boards. Are meeting notes taken for all those boards?
There's a requirement that there be minutes of those meetings.
Are those meeting minutes then sent to council?
No, they're all available online to all counselors and the community. They are posted under the city clerk's page, right? I'm trying to remember where we put them. Okay, so yes, they're all publicly accessible as soon as they're adopted by the Board or Commission as approved.
Okay, so most of our boards and commissions meet on a monthly basis, if not twice a month. There would be meeting minutes that are available to all of us. So as we talk about other letters coming from board chairs, I think that it sounds like that's something we want to talk about in respect to different boards. Right, the Wheeler and CCLC advisory boards might be a little bit different than some of the other boards that are doing quasi-judicial. So the reason I bring that up is just so that everybody understands, meeting minutes are available. If we want more of a conversational from the board chair, that would be different, and it would probably be something that we would look at for certain boards, but not others.
So like as an example, best practice is that a board or commission chair comes in, spends 15 to 20 minutes with the council once a year, spends a little bit of time talking about what happened the next year, and then presents it that board's work plan for the upcoming year, so that there's an opportunity for you to adjust it. That is a little unusual. Shadows over there, isn't it? It is a little unusual for to do it at a quarterly is a pretty quick cadence. And I want to just be honest with you about that, when the agendas of all of these are all available online for everyone to see at any point too about what they have going on. But we'll take that back and talk with staff liaisons and chairs and find out what that looks like. And then also, what's that format? I would like consistency across your chairs and the formats that's presented to you. And that way there's clarity upon that expectation.
Yeah, I appreciate that, because we have a couple of examples of where that has not been executed very well recently.
That's all that I have for this topic, unless there's something else that you'd like me to focus on. If not, I think we have, I think the primary effort that we need to do is work on those changes to the code and also to the alignment of those bylaws. And then there may be some questions that come up through that process, especially as it relates to hybrid meetings, but we will, we'll be back.
I appreciate that. I do think that council appreciated and enjoyed our meeting with the Wheeler Board recently, and also I think we found that to be a good communication and expectation setting. So I think that we would enjoy, as we said, having meetings and updates on an annual basis, if that's possible, or whatever it is. But we would love to meet with our board so that we have that direct communication in room. Jen, is that all on that boards and commissions? Because I do have one other thing.
Yes.
Okay.
Is there a slide you want me to go back to, or are you good? Okay.
No, this dovetails into the conversation that we're having and I just want to use this as an opportunity to share this. So as council members have referred, we received a letter today from the CCLC board, and I really enjoyed receiving this kind of update from CCLC, and it was very welcome for me after having some conversations about wanting to see this kind of communication. However, and I'm going to speak a little bit to it because we have some members here. The letter itself gave me pause because I found that some of the things that were characterized in the letter weren't really in keeping with necessarily the enabling ordinance that set up the mission and roles and responsibilities of the CCLC. And so this fits under that second bucket that Bill was talking about. One is about process, but the other is about fulfilling their missions and such. And so where I had pause on this letter was that it starts off by saying that we are a volunteer group of local business owners that care about the Aspen community and businesses in the downtown core. Well, it is not a group of local business owners. That is not in the enabling ordinance. The references to business as far as CCLC's charge is more minimal than other primary concerns for the CCLC. And as I read through this letter, again, it refers to wanting to work with ACRA in helping businesses, and that's not in my reading of the enabling ordinance of 2007. That's not really what the charge is. And so in basic terms, what I'm saying is that the CCLC in this letter refers to their role in supporting business and connecting business and partnering with ACRA. Now, it does have other references talking about events and things like that. And when I referred to the enabling ordinance, it talked about that as well. It talked about things like parking, circulation, downtown enhancement, events, and that kind of thing as related to business. But it's not, the CCLC is not the mouthpiece of the downtown business. The CCLC's charge is to make a downtown core that works for our residents, visitors, and businesses. And I, for one, for example, I would love to have more CCLC input on things like the outdoor dining or bars that are set up currently on Hyman Avenue that probably one day will be restored to Cooper Avenue. I'd like to hear CCLC input about the one-way streets on Hyman and that intersection and safety there, which is in their enabling ordinance charge. So I just wanted to bring this up at this meeting. I did reach out to the chair. The current chair of the board, I believe, is Charles Cuniff. I reached out to him. He has not been acting chair for very long. But for example, the letter that was given to us was drafted, I believe, by the vice chair. I don't know if it was agreed and accepted over email or if it was agreed and accepted in a meeting and the like. But I love the communication, but I just felt like some of the messaging that came through in the communication was divergent from the actual enabling ordinance and the description of what CCLC should be doing and acting in capacity. So I wanted to bring that up in this because it relates to kind of those roles and responsibilities, what our expectations of our boards are. And so I think referring to that enabling ordinance for this board and others is very important for us so that they don't get off track. If we need to make changes to that, that's another conversation. But what is there now is what our expectations should be based around. So thank you for hearing that out. I just wanted to add that to the conversation as we try to align our boards with the mission and purpose of what we're trying to achieve for efficiency and effectiveness. All right, with that, sorry to jump ahead topics. Let's go back to email transparency.
It's all good. So as you heard earlier, and as you well know, the Colorado Open Records Act ensures that emails sent to and from public officials or public documents, there are limited exceptions, and attorney-client privilege being one of them. We heard this evening that there's been 70-some CoA requests that have happened through year-to-date for this year, and only 2 of those have gone to council, but sometimes those coincide with those large community conversations that are happening. So approximately 5 times per year, the city attorney's office asks for email records from the counselors, and that may include also text messages when there's a CoA request. This conversation is in particular related to email transparency.
I'm going to interrupt for a minute and just step back for a minute. Why are we even talking about this? What we're talking about is we do keep hearing you talk about transparency and wanting more of it, and CoA requests are taking up more and more staff time to fulfill. Is there a way to not put the public through that formal process when it comes to the emails of the council members on city business? And so what Jen is sharing with you tonight is a solution that we've been seeing some other municipalities implement that we think would offer a lot of transparency to the community in your communications. So now I'll turn it back to you.
And I think that there are a number of communities that have probably grappled with that exact conversation, and that is why there are these solutions that are out there that are implemented other places in Colorado. That there are jurisdictions that have voluntarily decided to provide email to and from council through a public portal, exactly for transparency reasons, a commitment to that. Also to make it easier for people to access the information that they need, rather than sending a CoA request that does take time to get through staff. And so there is a solution that staff has researched that is the solution that both Fort Collins and Loveland use. There's Estes Park and Larimer County use something that's different, but it's a similar kind of portal where you can go in and access the emails, and you can see everything that's there that has gone to and from the council, with the exception of something that's been identified as needing to be held out. So private content, confidential privilege, attorney-client privilege, marked emails. So this is kind of what the interface looks like. And this is what it looks like when you get the password and you go in. I just grabbed a screenshot, but you can look at all of the emails, and you can do search. Actually, I'll go back. You can search if there's something specific that you're looking for. So as Sarah mentioned, that this could create an easier path for those folks who are looking for information. We recently received one related to House Bill 1255. Somebody could easily put in House Bill 1255. They can get all those emails that probably primarily John and Tori, where there was some conversation back and forth with Cass and other folks who were active on that issue. So again, this is what that interface looks like. I think that the overwhelming reason that a community does this is because of a commitment to transparency. So that, as Sarah was mentioning, there certainly has been a lot of conversation related to that. So this is one avenue to provide increased transparency in the organization. And I'm open to any questions that you might have.
How many did you say were utilizing this kind of system so far, or is it
In my
versioning?
research,
Is it where are we with this technology?
the communities that have had this have had it for a number of years. Fort Collins and Estes Park and Larimer County and Loveland, I think, is the one that I didn't mention, are the ones that I'm familiar with. There are other communities that publish all of the emails that are sent to all of council. So that's something that Louisville does, which is a little bit different than each individual email. I don't know that I have looked to see, I don't know that there's a clearinghouse for finding out all of the communities that use a system like this, but these are ones that I'm familiar with.
Okay. Bill, questions?
Thanks. Jen, you mentioned getting the password. What did you mean by that?
So in your packet I provided, there's a link to a page, and basically you just put in jen.uten@aspen.gov. It sends a password and a link to your email so that you can access this particular interface. So, and it takes 2 seconds. It's just like getting kind of like a multi-factor authentication.
And why does one, what's the like theory behind why one needs to register to be able to access this?
It's not a registry, I think it's, I don't actually know the answer to that question. We certainly can ask the vendor, that we've researched why they do it that way. But that is the system that they have. It's just, it's a common password. I don't think that it is specific to Jen or to Sarah or to someone. I think it's just basically an access to get that information for that community.
Yeah, I'd like to learn more about that. It seems like perhaps it might be, unless there's a valid reason for it, it might be an unnecessary hurdle. Yeah. Separately, could this, is there something that you've come across that could be used either in addition to or in place of something like this, that functions sort of like a Slack channel, if you will, like a bulletin board type of thing? What I have found to be an impediment to perhaps some efficiency is the fact that we can't break this open meeting law, of course, and you know, for some of the more mundane stuff, is there a place that it could be published, even if it's in real time for people to observe, but it doesn't have to be in the form of a meeting? Is there some kind of system like that that you've seen?
I am not aware of anything like that. That isn't something that, I'm certain that there are probably communities that have a staff member who provides some of that kind of information. But I'm not aware of a technological solution that does what you're talking about. And maybe Sarah has a better answer than I do.
Yeah, so, right, Slack is interactive back and forth, and the closest thing we have is Aspen Community Voice, because it still maintains the separation necessary to comply with statute around some of these open meeting laws. The alternative of one of which where a council member can then go respond on it, like a resident puts something out there, a council member responds to it. It's still going to be an open meetings violation if there's multiple council members in there. And so that is something we would have to see. I actually have not heard of anywhere in Colorado using anything like this. Have you, Jim? Because the open meetings law kind of throts it down immediately.
But
Our intentions
yeah,
here
I'm
was
curious
just
if there's a way that we can observe the open meetings law. Like, here's the live access to this, you know, we'll call it a Slack channel for lack of a better term at the moment. Like, anyone can see this, anyone can participate. We'll you know, when Sarah poses the question that she wants feedback on from counselors, maybe that is the public notice, right? Like, maybe that triggers a public notice automatic. I don't know if this exists, or I'm brainstorming some idea that doesn't exist yet or not, but like, I'm thinking that some stuff that takes time in meetings could be efficiently resolved on sort of everyone's individual schedules electronically.
Sure, so the closest thing to this is live polling. And I actually don't know if we can even do that in a public meeting, use live polling. I would have to defer to your office, Jim.
I'd have to think about this and other questions you're raising. I'm not aware of other places that have done it, but you do have serious noticing issues to all of it. And the courts that have said that emailing have never discussed how there might be a way to do that without violating the open meetings law. It's just nobody has suggested how to do that.
Yeah, I should ask Tim while he was here if, I'm drawing a blank on his name, I'm sorry, but. Sam, should ask Sam that question if he knows of anything, so maybe someone could follow up with him and see if he might be aware of something. I don't want to reinvent the wheel here, and I certainly don't want to create a custom technological solution for us, but if something like that exists, I think it could bring a lot of efficiency.
Yeah, the questions I had were the same as Jim is, you know, noticing, but also, are there times where you could enter into something that you're opening the privilege on related to a matter that.
Right, and the council can always waive privilege.
Right.
In most circumstances, there's only one or two I can think of the council cannot unilaterally waive privilege on. So what really our request today is though about using a technology like this as a very different landing page when you come to it. What it essentially involves is that we have a staff member who is assigned, who is knowledgeable about attorney-client privilege, confidentiality requirements under personnel matters, as an example, and who takes about a week, takes 20, 30 minutes, skims the emails that would get published just to make sure there's not something missing. And then about once a week, we batch load those in through the portal for anyone who wants to search for them. The cost for this is pretty nominal. Can you remind me?
I think it's about $5,000, but it depends on if there are any other kind of bells or whistles, but I think, $7,500 is one that I've heard for, I think it's Fort Collins, maybe that.
But that doesn't include the staff time to do the reviews and the batch.
It does not. However, when we did our talk with Jim and his team, the reality of the amount of time they spend on CoA requests versus what this might resolve for them, he was kind of like, it could be a wash. Might not be, but there's a chance that it could be a wash for that office.
Yeah, I support some kind of transparency, and I think that Aspen Community Voice and Home Trek both require that you register with AppChar, with a Community Voice. I'm not sure why that is, but it's as long as this is available not only to us on the city council, but to the public. I think that all of our emails we should consider as postcards, that they're available for everybody to read. So I support this, but I'm I don't want open meeting laws to be violated, and I'm also desirous of information that is shared between some staff members and individual council members to be shared with all, so that all of us on council have the same information to base our decisions on. For example, if I make a request of Ben, let's say, on a particular item that's on the agenda, Ben replies to me, that we have a mechanism to share that answer with all of the council members.
I was just going to say that I think it's the expectation. For example, there was a question that came to you over the weekend. It was forwarded to me. I answered that email to the member of the public, and then I subsequently sent you that answer so that everybody has the same information at the same time. That's a standard practice for staff. If there's a case where that isn't happening, we're happy to make sure that it is happening in the future.
Council members, yes, we have
Open to
one,
further
two,
exploring
we have interest in furthering this effort. Yes. Interesting. It's a new world every week. From the broad policy, I'm all for putting the energy and effort into figuring out a system that works. Do I think that this is it? I don't know, but I support the overall goal.
All right, thank you very much for your time this evening.
Thank you, Jen.
Thanks, Jen.
And thanks for responding over the weekend.
Council members, it's 6:15, so if you'll just indulge for a few more minutes, Sarah has just a few updates. One of them came up at council table recently in regards to the airport, so it's timely that Sarah gives an update in that area as certain things are happening around that topic. Sarah?
Thank you, Mr. Mayor. Two things, so the airport and CAS. I think if I could start with the airport, that is the more pressing item. And I'm going to share screen if that's all right.
Yeah.
Okay. Okay, so we're not going to go through all these slides. This is a slide deck that was used at the joint meeting last Thursday of the Board of County Commissioners and the Aspen Airport Advisory Board, and I attended that meeting remotely to keep up. This is just some historical understanding of what has been the public process over the last several years to get to increasing, let's see, to where we are this coming January. And that's really about the airport layout plan needs to get approved by the FAA. It has, as I mentioned before, the airport is now not meeting its grant assurance requirements because of the consistent failure of the runway, specifically the base of the runway has given away due to hydrological issues in that field in particularly. And so the BOCC needs to make a decision and is looking for assistance from the Airport Advisory Board. So what you see on the screen right now is the airport with the overlay of what were the common ground recommendations from about a 2-year public involvement process that wrapped up in 2019. Just to cover what some of these things are, is you can see with the runway and the common ground recommendation stays in the same place it's in today, so it's rebuilt in place. And that the local general aviation operations move to the western, which is the lower portion of your screen, for activities on that side. And the FAA has had rules around sort of how planes, both GA and commercial, need to be able to move around the runway. So what do the taxiways look like and where do they go? And without getting into too much, you can see this thing called EMAS. Think of that as essentially a crash barrier at the end of the runway, which is not warranted according to the FAA, but locally we may choose to fund that. And then also you can see where the new terminal is located. One of the things I want to, this future EV toll, what that means is where could solar panels potentially end up? Where's any on-site offset that might be considered for the project? One of the things that's really important here is that this shows the the FAA tower staying in its current location and configuration, which right now it's under 50 feet tall. And if you're not aware, when you're in that tower, you actually cannot see from end to end on the runway. And so on the left side of the screen is called the 15, on the right side is called the 33. It's just the numbers for the different approaches because planes can land either direction on this runway. And how the FAA deals with not being able to see both ends at the same time is that they have a camera system set up that allows them to see both ends of the runway to verify for takeoffs and landings. Not an ideal situation, but a very workable situation for air traffic control. But in a recent discussion with FAA representatives, both in Denver and then another conversation with them in DC, it really became clear that the common ground recommendations were not going to be accepted for the airport layout plan in its entirety. And so I'm going to just jump ahead a little bit. So this is the same thing. The FAA wanted to talk about a couple different things with us. First is that air traffic control tower. That air traffic control tower, should the runway stay in its current location, the air traffic control tower must be relocated to the east, so the other side of Highway 82. Additionally, they let us know that that tower will easily be over 100 feet tall, so more than twice what we have today. The last thing is that it would be at the local community's expense because there's alternatives that do not require a new tower be constructed that were being chosen not to be pursued. Okay, so there's a big one. The new tower excess, we've heard numbers from anywhere from $80 to $100 million to construct a modern day tower.
Quick question.
Yeah.
Where would it go on the other side of Highway 82?
Sure, so let's see, you can see my mouse. So you see this area right here?
I was afraid of that.
That's owned by the airport. That's next to the city's snow dump. So
And the other properties in red next to that, is that county-owned land?
That is county-owned. It's actually may even be, my recollection is it's airport-owned even.
Okay, thank you.
Yeah. So there's problem number one. Problem number two for the FAA is where these runway crossings are, they don't meet standard in a lot of cases. They don't like their alignment without getting too technical about it. And they said that has to look different on an ALP to get approved. The third thing they said is this taxiway is too short. You have the ability to make the west side taxiway longer. Now, just for clarity, this is over like right along Maroon Creek Road. If you're not aware, the city of Aspen, Owl Creek Road, thank you. If you're not aware, the city of Aspen actually owns the parcel immediately west of the airport through here. It is part of the Burlingame open space that has a conservation easement across it. That conservation easement is managed by AVLT. And then they had a problem with how this runway is shaped at the end. The short story is, a while back, there was an argument made to make the runway a little bit longer. And the way that this is shaped, you see where the runway comes here for takeoff and doesn't make use of this space right down here. The FAA said, nope, you have a grant assurance that the full length of the runway would be available. You must make the full length of the runway available. So what does that mean? I'll hit these things. These are basically all things that the FAA said are optional net local expense. The one of these I care about is the blast fence. And I think that the council would care about that too, because that may be what happens with emissions and noise across Highway 82 over into Deer Hill. So these conversations happened, and lots of different considerations came up. And I'm going to flip to what is likely to be what moves forward. Something like this, softer edges on those purple lines to actually handle navigation. But what it's happened is the runway has shifted 85 feet to the west, right? This was a really big deal in the community conversation in the common ground, was to not necessarily make this shift. It also places, so the runway is 150 feet wide, and it also places 400 feet between the taxiways and the runway. Now, different size planes can be accommodated with this layout than what we have today. That's known. Whether they come or not is what's unknown. So as you can see, runway crossings changed. There's more additional west side taxiway. This area over here is going to have a different alignment to meet that FAA grant assurance for the full use of the runway for takeoff and landings. And so I just wanted you to be aware that this is, in essence, the chair of the Airport Advisory Board has indicated she intends for a vote this Thursday on a version of what you see here. And so I want to remind the board, I don't have a voting position on the advisory board. However, I am a full participant in discussion here. This is what it, quite frankly, is sounding like is required in order to meet grant assurances and to keep the airport providing both commercial and general aviation at this time. And there's a lot of funding questions that the commissioners in particularly focused on in their conversations with the FAA about short-term dollars that are available here in 24 and 25.
Yeah, question. If this layout plan is adopted, does FAA pay for the new tower?
With this layout, the tower does not need to be relocated.
Does it have to be higher?
As of right now, I have not heard that indication. At some point, the runway will need to be modernized. The tower will need to be modernized, but it sounds like the schedule's pretty far out for that, but I can ask that specific question on Thursday for you.
Thank you.
Thanks, Sarah, for serving on this board and for bringing this to us. The reason I mentioned this, some point in the past was, I think it'd be good for you to have some clear direction from a majority position on what our preference is for the county and the Airport Advisory Committee to do. What weight that holds, I don't know, but I do want you to be something other than neutral. So that, just wanted to remind everyone, that's why I brought this up, is to be able to give Sarah some direction on what she should be voicing in these meetings. I think only one or two specific questions on this, Sarah, is has the FAA indicated whether they would generally approve what's shown here?
I think there's higher probability of success with what I've shown you here versus what the common ground recommendations showed.
Got it, thanks. Any idea if this schematic would allow for the airport to remain open while the new runway is constructed?
My instinct is that, well, I'll get that confirmed, but my instinct is no. I don't see how, I mean, night operations might allow some of the earthwork to occur, but I don't see there being no disruption to air travel from this. The run, I mean, a full rebuild on a runway of this, even though this isn't a big runway, this is a big project for our community.
Yeah, I'd be curious if this might result in lesser or shorter disruption. You know, maybe they can fly in, you know, aviation could be allowed in the mornings and the work could start at noon or something. I have no idea, but I'd be curious, you know, obviously we're not replacing it in situ, so maybe it allows for some more flexibility for the community. And then lastly, could you expand a little bit upon the blast fence comment that you made, please?
Sure. The FAA, based upon the environmental impact studies, don't show that a blast wall is required over in this area, right through here. However, through conversation on the board, there's a decision to show the potential for it. So in essence, reserve the space should the local community wish to construct that at some point. This goes also into some of the conversation of community concerns about emissions that during takeoff that go back towards Buttermilk and to those lift lines as another possible way to, in essence, push that.
Mitigate.
Yeah, you can't really mitigate it, but you can push
Deflect
it.
it, right.
Yeah, deflect it, if you will, higher up and not where as much of the human activity is occurring.
Do we have one of those now?
No.
No, so this would be a new thing. All right, I'm generally very supportive of you supporting this. Thanks.
So when we were preparing to bring this forward, I think that there is an important meeting happening this Thursday. Is that still on?
This Thursday is when the Airport Advisory Board, the chair has indicated the Airport Advisory Board will be voting on a recommendation to the BOCC.
And so, you know, I don't know that we really could, I don't know that we have a consensus position with the information that we have. But I wanted to get this, have this conversation anyway, because in light of the vote that's coming up Thursday. You know, I have so many questions around this. I'm supportive of a terminal rebuild. I am supportive of safety improvements and maintenance improvements to the runway. And I don't have an issue with it moving, but the impacts that are potential to come from moving the runway and allowing larger airplanes to land are things that I don't think have been addressed and are things that concern me. You know, I'll give you just a quick example is that, you know, if there's greater access and there's more deplanements of visitors and the like, that puts greater pressure on some of our communities and our ability to serve our residents and our guests. Where I really see these impacts being greater than in Aspen, I think down valley communities are gonna see some of the home price inflation that we've seen in Aspen. They're going to see more pressures on agricultural lands to be transformed into residential and the like. And those are questions that are for our Down Valley neighbors, but are concerning to me. I don't know. I don't know. The way this whole conversation has gone around these, it just keeps coming back about the community states what the community would like and wants to move forward with some improvements at the airport. And then we get told by the FAA, or we get told through somebody, that the FAA says you can't have that, and if you want that, then we're going to just back out of your airport and we're not going to pay for anything anymore. Now we're being told that certain changes or non-changes would require a 100-foot air traffic control tower at the county's expense to be located across the highway. That to me would also probably require an underpass be built for connection of the air traffic control tower to the airport field itself. The way this has gone has just been really unsettling. So again, like I'm all for renovation at the airport and bringing it up to speed, but I have questions around the impacts that will come from it. I'm not prepared at this time to say I support this. I think that this has just evolved over the last week or two. I actually sat in on this meeting. I went over to the county building and spent a half an hour while they went over kind of these changes and the objections and the possible solutions around them. A question that came out for me on that was the new general aviation. It sounds like they are proposing to add some 60 parking spots for general aviation aircraft, private aircraft, if you will. I just recently, this weekend, had an occasion where I know that a commercial aircraft got diverted to Grand Junction, partly because there was a line of private or general aviation aircraft that needed to take off and land. And so I still have questions that are unanswered around where is our priority for this? What is the benefit to the community and the county? Those are answers I just don't have at this time. So I'm not able to support this full package going forward for this Thursday without more information myself and really getting to understand some of these details a little bit better. This started off, I served on the original citizen advisory commissions, committees. My experience there was not great, but then the overall committees did come out with these recommendations, and they were modified or rejected by the FAA. So I just have a lot of questions about what our actual input means. What can we actually get? I don't know about the trade-offs with the fixed base operator, if that's what it's called, the base operations, as well as private aircraft and what their priority here is. If there is going to be the ability for 50 or 60 more private aircraft to land here and stay here, where's the benefit flowing for that? I just have a lot of questions around this. So I'm glad that we're having this conversation. My expectation coming out of it would be that individual council members definitely can share their perspective with the BOCC or attend the meeting on Thursday, but I don't know that we've had enough conversation or information around this to just wholeheartedly endorse the plan that's in front of us. That's just how I feel. Ward.
Yeah, I have questions about this. On Thursday will be a vote to present this to the FAA for their approval?
No, the Airport Advisory Board needs to make a recommendation to the BOCC.
Okay.
The chair's indicated that that is the vote that she intends to hold.
Okay, and so it's up to the BOCC to present it to FAA?
The BOCC needs to approve what is submitted to the FAA.
Okay, and then my follow-up question on that is that the FAA has indicated they will not fund further airport repairs. There was a 10-year period in there that exceed 10 years.
Yeah, it's a grant assurance. It's a common thing. The city of Aspen has federal grant assurances too we've signed over the years. And it is that a guarantee that the, any need for additional work on that asset during that grant assurance period is at the what they call the local's responsibility, rather than the FAA continuing to, what they call is sending good money after bad because you're not fixing the underlying issue.
So the follow-up on that is, if this is presented, if it's voted, presented to BOCC, is that an indication to the FAA to hold in abeyance that decision? Will they continue to fund airport runway repairs while we're actively seeking an Aspen layout, or a airport layout plan?
I can't speak on behalf of the FAA, but I will tell you in general, what the message has been is that until there is a new airport layout plan adopted, that the old airport layout plan, which is not the common ground recommendations, is what stands. And therefore, the grant assurances are tied to the old airport layout plan from
70s?
no, it's like I can't remember, it's 2012 or 2015, somewhere in there. And so the hard truth is that this year, the airport is gonna spend about $1.5 million out of reserves to deal with a portion of the runway that was within a grant assurance. Next year, all the repairs will be at the expense of the county and not of the federal government. And that is estimated to be at least $7 million.
And to continue on this line of questioning, that Tori mentions some issues about growth and impact on the community, not only Aspen, up and down the valley. There's a long history of the concerns for the community members, but I believe I know the answer to this, but do we have the ability to control or limit employments?
The way the FAA has very clear direction from Congress that their first responsibility is safety, and very second after that is access. And they do not make a differentiation between commercial and general aviation in that access. In fact, they will not let one or the other be unduly burdened by the other. So therefore, the notion of limiting general aviation because it delayed a commercial flight, that is not in the nomenclature of the FAA. A plane is a plane. It is trying to take off or land, and it needs to be accommodated in the system.
So I thought, and it's first come, first serve.
For the most part, yes.
And as I understand it, we will not have, or we have a limited time that is from 11 to 7 when the airport can be used. And I've heard rumblings or suggestions that we may not be able to retain those hours of operation.
So I don't think those are the correct hours. I believe a plane can't land after 10 p.m.
7 to 10, yeah.
Yes, takeoffs can be between 7 and 10, as well as landings. That is an exception. There are some exceptions there that were made for the Aspen Airport, given its unique terrain around it. It is also at a time when there's, quite frankly, much better technology today than when that exception was granted. So at this point, I do not believe we're being asked to consider expansion of those hours, but I can ask that question to confirm this week.
Thank you.
John?
Yeah, speaking as a lay citizen, I just want to say this airport conversation does, I find it kind of disturbing that again, from a citizen's point of view, it seems like the FAA is basing our needs not just on safety, but also on growth, while we're simultaneously talking among local governments about how much more growth do we want. So that's where I struggle. Where is that balance? That's all I've got.
Bill?
John, can I ask you what makes you think this is growth?
Allowing larger planes that will allow more deplanements, I consider that to be growth.
There's a really interesting argument that I'd love to share that slightly larger planes might actually result in fewer enplanements.
Certainly possible, but in my short time here in Aspen, that's not been what I've observed.
Well, anyway, I think recently, from the Citizen Visioning Committee and stuff, they put forth and accepted a level of growth at 0.8% per year. And the response from the FAA was that did not meet their threshold for growth, and that for them to move forward, that we would have to accept, I think they ended up at 1.7 or something like that % growth annual. So the conversation very much was exactly about growth, and the word that we got back from the FAA was that we had to, that it was unacceptable. Our 0.8% growth per year was unacceptable to them, and that projects like this are predicated on a certain amount of growth, and they came back to us to require that something, I'm using too many words to describe a simpler process, but nonetheless, so it was a growth, it was, the issue of growth was brought into it, and it started at the Citizen Committee.
I'd like to join this conversation about growth. I also served on the ASE Vision on the Airport Experience Committee. And, Bill, I went in with the same idea that if we had larger planes, we could get the same number of people in here with fewer flights, and it might be less congestion. But then the argument is presented that we have to allow for growth, and more enplanements or more people coming to town, I think, would mean that in order to house those people, that it will force growth at the Williston Down Valley. So that's just something to factor in, as if we have bigger planes, more people coming into town, where are they going to be housed? And if we have we don't have the 1A online yet, but there's not a lot of, there's nothing really in the pipeline for a large hotel or visitor short-term stays. So I see that as a growth pressure down valley. And then finally, you brought up the question about the runway being open during this construction, and I feel, I don't know for certain, but I don't think that it's possible to do that. And so it means for a period of a year, I don't know how long the construction is going to take, but planes would have to either come into Eagle Vale, Grand Junction, and I wonder if Rifle is an opportunity. I thought that Rifle wasn't interested didn't want to have increased traffic, but that means that we have to do Grand Junction or Eagle Vale for our tourists to come to town. And I'd like to get a feel for how long a construction project we're talking about too, Sarah.
Sam, any input on the airport? Want to share?
None.
Okay. Is there any other further update on this item?
No.
Okay.
So it sounds like we don't have clear direction to give to Sarah?
Not about supporting what, from the information that
Or
we
not supporting it,
Thursday, no. Yeah.
Yeah, I don't think so. We have some outstanding questions, and
Yes, Sarah doesn't have a vote on this, but I think that it sounds like this is an alternative that's can be presented. And it would be, as Tori suggested, we should make our voices known to the BOCC, because ultimately, they're the ones that make a decision on what they're going to recommend for a layout plan.
All right, well, I guess I'd request and encourage you all to form an opinion on this and the airport redevelopment in general, so that Sarah, who's educated and smart and representing our interests on that board, even though she's non-voting, can reflect our position in her comments.
Thanks. Sarah, one other item you had for us?
Yes, the other is a quick update on the annual legislative meeting of the Colorado Association of Ski Towns that happened back on March 7th. Just wanted to let you know a few things from it. First, quite interesting talking with Mayor Mike Johnson regarding the influx of immigrants coming to Denver and to the state. His most interesting takeaway is he consistently hears there's people who want to work, and right now the federal government is what's in the way of the work permits to getting these people to a level of self-sufficiency that doesn't require local and state resources. And so he'll continue on his coalition with mayors of several other large towns and pushing changes to how those work permits or visas may be issued even in a temporary stay until whether it's asylum or whatever is the basis of the immigration is resolved. So just wanted to give you a heads up on that. That was a pretty interesting discussion. Also, Governor Polis stopped by, quite the exchange about real estate transfer fees. As you know, some of our fellow CAST communities have been wanting to pursue the right for a local vote about instituting a fee to help support affordable housing as a key funding mechanism. And let's just say that there's not alignment, and this will probably at some point end up in the state Supreme Court to get resolved. I think the other key thing, two things that I'll share with you is we had a great update from the Leeds School of Business on economic indicators, particularly taking a look at the mountain counties with ski resorts compared to the rest of the state. Some of the key takeaways I would say there is our tax rate growth rate is higher than the other portions of the state in a lot of cases. So not absolute dollars higher, but the growth rate is higher here in the last year or so. Secondly is when you look at unemployment versus jobs, we have a wider gap. We have way more jobs than employment, right? We see it around town, even if it feels like things are settling down a bit, that's not really working out. And the other thing that came with that, because of that tight labor market, saw a 7.8% increase in wages across the mountain communities year over year, and trying to compete for talent. So I certainly know that experience from the seat I sit in for the community. So those are some key takeaways from Leeds School of Business. If you don't know, you can always go see the CAST presentation slides on the CAST website. You just go to meetings, presentations, and they're all there for the last 10 years.
I was going to just ask, did that presentation draw out any of those unemployment or employment numbers into different sectors by any chance?
Yes. So I have hospitality versus professional, and so you can see those in the slides. If you want to see some of that breakdown, you're more than welcome to look that up.
Thank you.
I just wanted to mention, to add on to your comments about that, if anybody else saw that article.
Is your microphone on?
Just wanted to ask if anybody else saw the article in today's Colorado Sun about studies show Colorado property taxes are quote-unquote extremely low, so why do they feel so high? That does a comparison with cities across the United States and ties in with what I've heard from various clients of mine is a lot of people come to Colorado, and Wyoming in particular, as Justin Farrell wrote in Billionaire Wilderness, is because our taxes are so low or non-existent in Wyoming. People come here to invest in property to protect their investments.
Relative
to either coast, Texas.
Even the Midwest.
Even the Midwest. I mean, there's a list here of all the different cities that have higher tax than us. Salt Lake City, Seattle, Atlanta, Phoenix, Las Vegas, Los Angeles, New York, Dallas, Chicago, Miami, Portland. Portland's at the top of the list. We are lower than Salt Lake City. Denver is. Let me correct that. Denver's lower than Salt Lake City.
It's important to consider that relative to other tax revenue sources. So
Understood.
many of those cities don't have income taxes, or states don't have.
Understood. Again, Wyoming has no property tax. That's why
Nor income
Jackson-
tax.
That's why Jackson has the highest wealth disparity in the whole nation.
Sarah, I sat in on a CAS subcommittee on legislative issues, and I thought there was an indication to CAS from Governor Polis's office that if a real estate transfer fee was passed, that he would veto it.
Yes.
And then I think that also Carbondale was attempting to pursue a real estate transfer fee.
I don't know if Carbondale will be the one to do that, but there has been a coordinated effort of a few municipalities to take the first steps to see if it gets challenged. Yeah.
Thank you.
Just other things from the meeting, I won't go into it, but there was a demographic update from the state. The big thing is when you look at net migration in here versus natural migration, there's a little bit of cooling off in the amount of net migration into the state. Still going quite well, but affordability of housing is the number one reason why people are choosing to either not come here, is what we were told, or that the cost of housing was a determinant factor to leave. So just as a heads up about that trend. And then we did a legislative update, tons of stuff on a lot of bills. I'm really glad we have our folks over at Castile Bowditch tracking things for you, and you get those reports with more detail. And I think one of the things I was most excited about was spending some time with Scott Fitzwilliam, who promises me, and Senator Bennett's office as well, promised that there will be a farm bill this year, which has our request for the 99-year lease provision on Forest Service parcels, because that is what we need for the numbers to work to bring together our partnership for the redevelopment of the 8th Street Forest Station.
Awesome.
Any questions for me?
Go Farm Bill.
Yeah, so next meeting is in Durango in August, and then in Jackson Hole, I think, in October. Thank you.
Thank you for those updates. That's our agenda for this evening. We want to say thank you to GrassRoots as always. We do not have a regularly scheduled meeting tomorrow, so we'll be back again next Monday. Have a great evening. Thank you.